Hello. Today I am going to talk to you about conduct of litigation. What does that mean in the general world? When I say this to people, they have no idea what it means. And it means something very simple. What it means is conducting, as in doing something. Litigation, conducting litigation, as in law, as in the case, the court case. And that is it. Conducting, doing the court case. Now, traditionally, barristers, as I said previously, were at the end of the chain where you would go to a solicitor, the solicitor would prepare the case, and they would usually pass it to a barrister who would take it to court and fight the case. We have already learned that that no longer is the case, and you can now go to a barrister directly who you can get advice from. You can straight away instruct them to go to court for you, all sorts of things they can do. Then something else changed, which I think is wonderful because I trained as a solicitor, so it really is wonderful, that the conduct of litigation rules came in, which means that barristers can do exactly what a solicitor does. So what's the benefit? Anybody know the answer? Yes. The answer is the solicitor and barrister can now be rolled into one, and you get this, which is a direct access barrister who can conduct the litigation. So you effectively get two in one. You get the service of a solicitor and a barrister, all of the specialisms combined, and the barrister can do exactly what the solicitor does as well. So that means they would be able to correspond with the other side, they would be able to write letters on your behalf, they would be able to file documents in court, and vice versa. They could receive them and guide you accordingly. However, there is a however. There is obviously going to be a slight extra fee for this, but not necessarily massive, because it depends on what the barrister charges and what your agreement is with them. But even still, it is a really, really good service in my view, because what it does, it keeps everything about your case in one forum, and you don't have to worry about going to two different, or even in some cases, three different lawyers. And this way, everything is just very, very concise. If you are looking for a barrister and you feel you can conduct the litigation, which is all the, if I say the administration part of it, effectively, yourself, that's fine. You can save that cost as well. But if not, then you may want to hire a barrister who can actually do that for you as well at another cost, but maybe not a massive cost, and keep everything in-house effectively. I just want to explain something very simple with regards to billing. Solicitors, when I was in a solicitor's firm, bill very differently to barristers. So the billing of a solicitor is usually on an hourly rate, which means that the 1 hour is divided into 10 units. So every 6 minutes equates to a tenth of that hourly rate. So if somebody is on £200 an hour, which can be quite a lot, well, it is a lot of money, that means every 6 minutes will be £20 plus VAT. So you talk to the solicitor for 6 minutes, that will be £20 plus VAT. You get them to write a letter for you for 30 minutes, that will be £100 plus VAT, because that's 5 units. If I talk about myself, my hourly rate sometimes becomes ineffective because a lot of people instruct me for a particular job with a lump sum, and in that lump sum we will have a set of tasks which I will do for them. Yes, you may go over the time you've predicted, or you may be under the time you predicted, but usually I go over the time. But in that time, they know exactly what they're getting for that money. So there's no sort of hidden extras. Now, there's benefits and drawbacks of all sorts of billing, but if you are conscious of the fact that legal costs could escalate, which they will, I will tell you, every legal matter I've dealt with, legal costs can very quickly get out of hand. And I mean a lot, very, very quickly get out of hand. You need to make sure you hold the purse very carefully and decide which route is it I want to go down. Do I want to pay an hourly rate and then not know how much that hourly rate might come to? Or do you want to pay a fixed sum and then just keep it to that and keep dipping in and out of advice with the direct access barrister? A key thing I will also say is, as much as you will get on with your solicitor or barrister, they're not your friend. And this is where costs can go up. If you just keep phoning them or keep asking them for more additional advice than what you've instructed them for, your costs could go up. So be very conscious of that, because some people make the mistake of thinking, now that I've instructed somebody, I can just keep going to them. I can just keep giving them everything and anything. That's not technically correct. You can only do that for whatever you've instructed them for. So for example, if somebody instructs me to draft them a letter to the other side in response to a threat they've received, that's what I've been instructed to do. So anything to do with that, yes, I'll happily talk to the client about, or I will happily advise them about. But if they suddenly start bringing other problems within the case to me and start saying, well, actually, I need to prepare my bundle as well. Now I've instructed you, so you need to do that as well. Well, no, I can't do that because that will require separate instruction. But that is also the beauty of direct access, because you're paying for separate jobs separately. You're not indefinitely having this bill clocking up. So the choice is yours on how you proceed. That was episode 7. I hope that was useful. The next episode is, how do you give precise instructions? Adios.